Thank you very much. I'm going to start with a nod to sort of the historical right to data privacy, just so you don't think that data privacy is something that a bunch of Gen Xers and millennials came up with as we Twitter and Facebook and YouTube our way through the rest of our day. This actually goes a good bit further back than that. It's really rooted in the constitutional right to privacy the courts have recognized, and that right has been recognized in a number of different contexts. But what's interesting in terms of this panel is the right to data privacy for consumers as to information that is held by corporations about them. And that goes back a long way as well. Courts have recognized that since the 19th century, when American courts quashed subpoenas that were issued to telegraph companies for the content of telegraph communications sent by private parties. Private litigants attempted to get a hold of these things by way of subpoena, and courts realized that if privacy rights were not guaranteed for consumers in that context, that new technology, that then emerging technology, which had great benefit socially, would not be as useful to consumers and would not reach maturation. So that's the 19th century perspective. In 1890, Warren and Brandeis argued for a common law privacy tort in an extremely influential law review article. And that essentially influenced the development of common law privacy torts through the mid-20th century. Torts like intrusion on seclusion, public disclosure of private facts, breach of confidentiality, and appropriation. And we'll come back to appropriation in a few minutes in my talk and in a few decades in the outline. But he then moved on into the 1960s and 70s, where you have Roe v. Wade and you have Roe v. Whelan and some of those other cases. And one of the interesting things about Whelan was the recognition that of a constitutional right for individuals in preventing disclosure of personal matters. And that sort of forms the foundation for what comes in the next few years, particularly as digitization and computerization makes keeping records about individuals much more cost-effective and much easier. And in response to that computerization and digitization, in 1973, the U.S. Department of Health, Education, and Welfare issued a very influential report that laid out a number of what they called fair information practices. These were basic principles of information handling, data handling, and information disclosure that the recommendation was that they be encoded in federal law. Now, at the end of the day, they found their way into a lot of federal statutes in various different ways, but they never ended up in comprehensive federal privacy legislation in the way that the Hugh Committee thought that they should. These are pretty common sense principles. For example, the report recommended that there not be any government data systems that were by their very nature secret. No secret systems of records or databases or things like that that the government denied the very existence of. In addition, it recommended that individuals be able to access the records that the government and companies hold about them, know how that data is used, and prevent the use of information by the government and corporations beyond the scope of the purpose for which the information was submitted by the individual. So if an individual submits personal financial information for tax purposes, that information not then be used for different purposes by the government. If an individual submits financial information to a company for billing purposes, that information not then be transferred and used for different purposes by the corporation. The committee also recommended that individuals have a right to correct inaccurate information that's held by others about them. And it placed the burden on the data holder to ensure the accuracy and prevent the misuse of that kind of information. So those are the sorts of principles circa 1973 that the federal government thought should be applicable to digital records and personal information. But as I said, they never ended up in a broad federal data privacy law. Where they did get incorporated were sector-by-sector laws. For example, education records are governed by FERPA. Financial privacy is governed by a number of different statutes, including FCRA, the Bank Secrecy Act and its progeny, Gramm-Leach-Bliley. Telecom data is governed by the Cable Act, ECPA, Wiretap Act, Stored Communications Act, number of different things. Employment records are, in many cases, covered by FCRA, in some cases covered by the Polygraph Act. And then you have other sector-by-sector laws that are not as broad as things like education records or healthcare records. There's federal privacy law on video rental records. You can thank the confirmation process for Judge Robert Bork for that. There is federal law on the privacy of data related